Howdy, my name is Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I represent folks who've been charged with a crime in Houston, Conroe, or the surrounding counties. Today we're going to have another installation of our series of videos called The Dirty Little Secret, and those are videos where I discuss a specific crime and I tell you something that us lawyers know that maybe y'all in the general public don't know. So today's crime is going to be assault family member felony. This means second offense, and assault family member felony is a third-degree felony. That means that the punishment range is going to be higher than in the initial type of case. So what is an assault family member charge? A third-degree felony, assault family member second offense it's an assault bodily injury case where the person who's the victim is either a member of the family, household, or has been in a dating relationship with the person who's alleged to be the defendant. So you cannot really get to an assault family member third degree unless you've been previously convicted of an assault against somebody in your family, in your household, or with somebody you were in a dating relationship with. So the key there, and the key to fighting some of these charges, is making sure the prosecutor can prove that that prior conviction was against a family member. Now, if that proof seems pretty evident, there's a judgment. It says there's an affirmative finding of family violence on that judgment, then a good lawyer is going to know maybe we should waive that requirement for the prosecutor to prove that, because if we don't, then maybe the prosecutor gets to go into all the gory details of a prior case where things went wrong, and it's going to be very difficult to challenge that case if the period is already over. There's no way to appeal the prior case, no way to challenge it legally. If that old case is on the record and it's cemented in stone there, then maybe the best thing to do is make sure the jury can avoid hearing it by objecting and maybe just pleading true to that and attacking the merits of the first case. Or maybe that case is bogus and we need to attack every part of your case. So that is another way to challenge an assault family member charge. Can a protective order in an assault family member third case kick me out of my own home? The answer to that is unfortunately yes. A magistrate judge or the trial judge can issue what's called an emergency protective order that lasts for 60 to 90 days, and it can kick you out of your own home. They're more likely to do that in a case where the case is a felony, and it's a much more difficult road to hoe for your defense lawyer. But it doesn't mean that all hope is lost, and it doesn't mean that the case is going to stick around forever. One thing that is really popular among prosecutors on these types of cases is charging them as a felony if it's available, but then pleading the case down to a misdemeanor. These are not the favorite cases of every prosecutor, and if they appear challenging, or your defense lawyer is able to make it appear that it's going to be a very challenging case for them to win, you may get a better plea offer. Can you be prosecuted if the victim drops the charges? Yes. The state of Texas is the victim in a case of assault family violence as far as legal purposes go. Now, the person who was injured or alleged to have been injured, that person is listed either as a complainant or a victim in the offense report, but in the legal language of the charging instruments, the state of Texas is going to be the one in control of the case. That can be good and bad. It can be good because whether the victim really wants to prosecute or not, the case could still be dismissed. But it can be bad because if the victim has already signed a letter of non-prosecution or an affidavit of non-prosecution, then the state may still continue with the case even after one of those is signed. What is the punishment for an assault family member second offense? It's a third-degree felony, and the punishment is from 2 to 10 years in prison and up to a $10,000 fine. You could also receive probation for up to 10 years or deferred adjudication. Now, a plea to deferred adjudication here could also be used against you in the future to enhance a crime. So let's say we are able to successfully challenge the prior conviction, reduce the case down to a misdemeanor. If you were to then plead guilty and get a deferred adjudication on a misdemeanor case, then that could still be used against you in the future. There's a whole web of enhancements that can be used against criminal defendants, and it's critically important that you hire a defense attorney who understands those when you're making these tough decisions. The dirty little secret with this offense is that these charges can go all the way from a Class A misdemeanor with no jail time and a fine only to 25 years to life in prison. The range of punishment for causing a bodily injury is extreme. And a prosecutor could be charging someone who has 2 prior trips to the penitentiary. They could charge them with 25 years in prison as a minimum in some of these types of cases. And so having a lawyer that understands that range and isn't scared by it, having a lawyer that can look at the facts of the case and say, we can beat this case at trial. I know that there's a high punishment range, but this is not the case that the prosecutors want to handle. And having a lawyer that has the rapport with those prosecutors to get them to understand this is not the case they want to go to trial on, that can make a big difference.